Welcome to the National American Indian Court Judges Association's Tribal Legal Advocacy Training webinar on how to establish a tribal public defender. The National American Indian Court Judges Association, NIJA, is a national nonprofit membership organization devoted to supporting and strengthening tribal justice systems through education, information sharing, and advocacy. NIJA provides broad and comprehensive training and technical assistance to support tribal justice system capacity building and partners with national organizations to educate the broader legal community and public about tribal courts and judges, and builds relationships between tribal and state court judges. NIJA is the Tribal Justice Training and Technical Assistance provider under the Bureau of Justice Assistance Tribal, Civil, and Criminal Legal Assistance (TCLA) program, offering training and technical assistance to TCLA grantees and sub-grantee legal aid organizations. NIJA's TCLA program seeks to increase and improve access to legal assistance in Indian country by providing training and technical assistance for the development and enhancement of tribal justice systems. Further, TCLA will assist in strengthening the capacity and the quality of indigent criminal defense services and defense strategies for tribal justice systems. NIJA is coordinating and implementing a multi-part training series, including webinars, interactive virtual training modules, and podcasts covering the basics of tribal court advocacy. The training series is tailored for entry-level legal services attorneys, either just starting out or those looking to bolster their tribal advocacy skills. At the end of this webinar, we will provide information on how to access the rest of the Tribal Court Advocacy Training Series. In developing the Tribal Legal Advocacy Series, we partnered with the Center of Indigenous Research and Justice, CIRJ, located in Olympia, Washington. Our presenter today is Ron Whitener, the president of CIRJ. CIRJ provides public defense services to tribes in Western Washington and training support to tribal public defenders nationwide. Before founding CIRJ, Ron previously was the founder and director of the Tribal Court Public Defense Clinic at the University of Washington Law School, and he continues to serve as an affiliate professor at UW. In 2011, Ron was named a champion of change by President Barack Obama for his work supporting and encouraging public defense in tribal courts. Ron was appointed the chief judge for the Chehalis tribes for 4 years and also for the Tulalip tribes for 6 years. Ron retired from the Tulalip bench in 2020 and currently consults with tribes across the United States on tribal justice system development through the Whitener Group, a consulting company Ron formed with his brother and niece in 2009. Ron is a member of the Squaxin Island Tribe of Washington State and continues to be active in his tribal community through commercial treaty fishing and serving on tribal committees and commissions. In today's webinar, How to Establish a Tribal Public Defender, we will give an overview on the steps to take when creating a tribal public defender position or office. Thank you so much, Ron, for joining us today.
Thank you for having me. Today we're going to talk about setting up a tribal public defender and a little bit about the history of tribal public defense and why there's not already tribal public defenders everywhere and why do some need to be set up. So we're going to go over some of the, we all know about public defenders, right? We grew up watching TV, watching Law and Order, if you're as old as I am, Perry Mason. But we know that there's a right to an attorney if we get charged with a crime and we can't afford one, that will be provided one. Now that comes from the 6th Amendment of the Constitution, which provides that defendants charged with crimes have the right to the assistance of counsel. The United States Supreme Court interpreted that basically to mean that if someone is indigent and either the state or the federal government charges them with a crime and they're low income, below some level of income, then they are afforded appointment of a free attorney to represent them in the criminal matter. And that came from Gideon v. Wainwright in 1963. The Indian Civil Rights Act of 1968 was created because the Bill of Rights, of which the 6th Amendment is part of, does not apply to tribal governments. So the Bill of Rights only applies to the federal government and then was applied to the state governments by the 14th Amendment to the US Constitution, but that didn't apply it to tribal governments. So when a tribe is charging someone with a crime, they don't automatically get a Bill of Rights, 6th Amendment right to an appointment of a free attorney if they're low income. And the But the Indian Civil Rights Act also limited the number of days you could be held in jail for a crime, limiting it to 1 year. So it didn't provide an attorney, but it provided a cap on how long someone could be held in jail, and also capped it at a $5,000 fine. We've seen a little bit of changes to the law. In 2010, the Tribal Law and Order Act amended the Indian Civil Rights Act to require that a tribe provide counsel to a tribal member or who's charged with a crime if they're indigent, and that crime carries a penalty that could exceed a year, up to a maximum of 3 years. And then if they're charged with multiple crimes, up to a maximum of 9 years if they're serving their 3-year terms, for instance, consecutively, and limiting them to a $15,000 fine. So we saw the Indian Civil Rights Act expanded to allow longer jail sentences, but if a tribe wanted to take advantage of that, it had to be able to provide a public defense system for people charged with those crimes. Even prior to the enactment, though, of the Tribal Law and Order Act, many tribes chose to provide public defense services free to low-income defendants in their courts. If you look around, for instance, the Colville Public Defender here in Washington State, it's been around a long time and has been providing that service. We see a lot of tribes that use lay advocates or spokespersons to provide that service, and they've been doing it for a long time, well before the Tribal Law and Order Act ever made any situation require a public defender. Tribes wanted to do that. There's a pressure from their membership. Their membership knows that if they're in state court or in federal court, they would be afforded a public defender. But they also know that if they're in tribal court, they don't, and they want that same equal right. So they push for the tribe to provide it. And we've seen some tribes doing it for a long time. For a long time, a lot of tribes couldn't afford to do it. They were funded by the United States to provide a justice system, which included a prosecutor, but the funding specifically didn't provide funding for public defenders because there was no right to public defense under the Indian Civil Rights Act. Now, in the area of civil legal aid, many tribes also provided free legal services to indigent parents, not as many as provided it in the criminal setting, but like Colville, also there was a civil legal aid wing of Colville tribes to provide civil. And we do see that as much. We don't see it as much as criminal, but we do see it. We're starting to see more and more tribes providing attorneys to parents who have had their children taken away from them, their rights to parent taken away from them in a child welfare proceeding. We're starting to see more tribes providing appointments to those. Those are expensive because there's usually 2 parents in every case. And under the conflict laws, it's very difficult for one attorney to represent both parents. So usually you need 2 attorneys or spokespersons to be able to represent the parents in a single child welfare case. The other, in addition to public defenders that are employed by the tribe, we've seen tribes get contracts with outside practitioners to be able to provide public defense. And then again, we've even seen like licensing and training programs created for what we call spokespersons or lay advocates, or people who have not usually gone to law school and haven't passed a state bar and is not a state bar licensed attorney. But we see some tribes setting up training programs for spokespersons to be able to do it. So it's sort of a mishmash of what these programs look like around the country. So what we tend to see for models that tribes set up, it kind of depends on what resources are available to them. For sort of the most classic is a public defender office that's an agency within the tribe. We see that, for instance, at Colville. We see it at Lummi here in Washington. We see it in a lot of places where it's just another department. And very well institutionalized. Or we see contracts where you enter into a contract between the tribe and an outside law firm, for instance, to provide public defenders from their attorneys, or have a list of what we often call solo practitioners, or a mix of law firms and solos that will take public defender appointments in the tribal court. We also see the use of independent nonprofit organizations like mine, Center of Indigenous Research and Justice. We're a 501c3 incorporated here in Washington State. That's a partnership with the University of Washington Law School. And we contract with tribes to provide public defenders for adults and juveniles in delinquency and some child welfare cases. There's many state public defenders are also nonprofits. So for instance, the Snohomish County Public Defender, which is the county north of where I am here in Washington, is a very populated county, heavily populated, and they use a separate nonprofit called the Snohomish County Public Defender to provide services in Snohomish County. And as they've been doing that, the Snohomish County Public Defender as a nonprofit isn't tied to any government, so they can take other contracts. So they're taking conflict cases in the Tulalip Tribal Court. They're providing conflict representation in some of the other counties. And so these nonprofits can be very flexible as well as an alternative. The nonprofit 501c3 is also important because the program, for instance, that this is funded over, this webinar, does have some funding for providing direct service for tribal public defense, but you have to be a 501c3 to be eligible for it. So that's another reason why it may make sense for a tribe to use a 501c3. And then less common, but ones that we see is similar to the Tribal Court Public Defense Clinic that I created at the University of Washington Law School, which is a clinical program in a law school. Law schools have and are required to have a law clinic, which is a place for students to actually practice law. It's like a little mini law firm within the law schools in the United States. And they take a variety of cases. Often they'll do housing, they'll often do criminal defense, they'll do unemployment, tax, all kinds of things that they do. And we've seen a few of them will take criminal cases, criminal appointments to provide public defense services to tribes. We see that at the University of Washington, of course, at Gonzaga here in Washington also does it. And it's just a pretty common model for clinics. Even if the clinic isn't dedicated to doing criminal defense, if it does sort of all kinds of things, often it will take on criminal cases. Now, if you've got a public defender, you also have to have a conflict program because the defender is going to get conflicted out of cases. What that means is that under the rules of professional conduct that basically regulate all attorneys in the country, State Bar Association licensed attorneys, there's a there's a model that's used pretty much by all states for rules of professional conduct. And in those conflict rules, there's some things that attorneys are not allowed to do. So for instance, attorneys are not allowed to represent a client if they're going to damage a previous client. So if I have a defendant who's charged with an assault, but the victim is my previous client, and I know information about that client, I'm not able to represent my client, the new client, diligently unless I damage my previous client, and I can't do that. So I'm conflicted out of the case. I would not be able to represent the defendant in that situation. Another situation that's really common is when you've got multiple defendants out of the same incident. The classic one I like is you've got 5 kids get caught with alcohol, and they all get charged with minor in possession of alcohol. Well, you can have one attorney represent all 5 as long as they sign waivers, and there's a pretty convoluted ways that you have to get consent and everything. But the problem is that all of their interests have to align. So let me give you a hypothetical where it can go south. Say you've got 5 kids, but one is 18, and the 18-year-old's the one that went and got the beer and brought it and gave it to the other kids who were, say, 14 years old. Any prosecutor is going to target that 18-year-old for getting the alcohol and providing it to even younger kids. So they may offer to one of the younger kids a plea bargain that says, we will dismiss the charges against you if you will testify against the 18-year-old. Well, I can't represent the 18-year-old and the 14-year-old because the good argument or the good advice from the lawyer probably to the 14-year-old is take the deal, testify against the 18-year-old and get your case dismissed. But if the 18-year-old is also my client, I can't counsel the 14-year-old to do something that harms my client, who's the 18-year-old as well. And so in these situations, generally, you're going to find a lot of times that a public defender is not able to represent everybody charged with a crime. And so you need escape valves of people that can take these conflict cases. What we often see, again, similar to a tribe that has contracts with direct providers that are their primary public defender, they'll also have separate contracts to do conflict. So like I said, Snohomish County Public Defender takes conflict cases. So the Tribal Court Public Defense Clinic at the University of Washington is the primary public defender at Tulalip. They take all cases unless they have a conflict. If they have a conflict, one of the firms that will take some of those cases is the Snohomish County Public Defender. And so, as well as often there's multiple solo practitioners or very small firms who do criminal defense, they'll also take public defense contracts out of the tribal court to do conflicts cases. So funding is the biggest barrier to developing the public defender. They're not cheap because, you know, if you want to have attorneys, right, because of Tribal Law and Order Act or the VAWA reauthorization, situations to where you have to have a licensed attorney doing the representation, well, attorneys are expensive. So that's the biggest drawback to a tribe in terms of trying to set this up, is it's not usually a very cheap thing to do unless they don't have a lot of cases, in which case you can get by with, you know, we have some contracts where, you know, it's $30,000 a year, $40,000 a year. But if it's a small tribe, that's a lot of money still. And so and there isn't a lot of funding that's directly supportive of it. So usually what you find is the tribe that wants to do this is going to have to put up its own money that it's getting from its tax surrogates like gaming or other economic development or other tax programs that they have. But they're going to have to take it out of what we often call tribal hard dollars, or dollars that aren't grant dollars or money from the federal government. So that really depends on whether or not the tribe has those hard dollars available to be able to provide funding for a public defender. There is very little federal funding for public defense in tribal courts. The tribes and it varies from state to state. So I'm not going to get into why certain states have tribes that get more money for their justice systems than others. But in many of the states, the tribes get what we often call base funding or justice system funding from the Bureau of Indian Affairs. For a long time, you couldn't use that funding for a public defender. It specifically didn't allow you to do it. They changed it to allow you to use it for a public defender, but they didn't increase it. So it's not like there was money. It wasn't like they had a public defender salary floating around and they just couldn't use it because they weren't allowed to. I mean, there's always never enough money from this source. They underfund it. And so allowing tribes to use the money for public defender really didn't make much of a dent in it because, you know, they would have to lay off somebody to hire a public defender if they were going to do it. So that funding isn't very helpful. The tribal criminal and civil legal aid money, the TICLA money that funds this webinar, is a rolling grant that tribes can get, but it's not stable funding. You can't count on it. You can certainly use it to start a public defender, and many tribes have used it to start a public defender, but they have to find funding from somewhere else to keep it going once the grant ends. And so that's not a secure area either. You know, you can look for funding from foundations or other private places, but public defenders, you know, giving criminals attorneys isn't the sexiest private funding argument. You know, they'll give it to charities like hospitals and health research and charities that help children or elders, which is totally makes sense. The criminal defendant is not usually high on the list of priorities for most private funders. So that's not really, you're not for foundations or other nonprofit agencies, you're not going to be able to do it. You might be able to do like many tribes have done in getting support through an educational institution. If it's a law school that has a focus on Indian law, and this could be something that they would be willing to spend their money on to have an opportunity for their students to be able to practice in tribal courts. You might see at least partial funding coming from a school to support a public defense clinic in that school operating at a tribal court. So if you do have funding, then you really want to take your time. You don't want to just throw this together because it's going to be a little bit of a shock to the system. If you're in a tribal court that exists, that has operated for a long time without a public defender, just sort of having one show up one day probably isn't the smartest politically and systemically. for the court. So you want to really create a team to talk about how to develop this. The team should absolutely include representation from these parts of the tribe, the tribal court, obviously. The court is going to be the one doing the appointments of the attorneys. Sometimes the court is the one tasked with, for instance, managing the conflict contracts and the primary public defender contracts. So it's really important to make sure they're involved so that they know what they're doing and develop processes to start appointing and how you're going to determine eligibility. Usually that's done somewhere in the tribal court. The tribal council, you need support from them, obviously. They're going to have to sign off on the funding. So working with them to do it, we've seen some bad situations where we had a tribal judge who just decided that he was going to start appointing people. He didn't have any money to pay them. He just started appointing them. And then they started appearing in the tribal court representing criminal defendants, and they started sending bills to the tribe. And the tribe was like, had no idea what these things were. You don't want to do that. That blew up, didn't work so well. You want to get buy-in from the broader community, especially, and usually you can get that because if the tribe has been prosecuting largely tribal members from that tribe for crimes and haven't been providing them an attorney, that's probably been a little bit of a burr under the saddle of people in the community who want their family to get representation, especially if the prosecutor is an attorney. We see that a lot where places are talking about, well, the tribe has an attorney that's a paid attorney and licensed attorney to prosecute, and I've got to send in my grandson who doesn't know anything about what's going on, and he gets to defend himself against an attorney. That's not fair. So buy-in from the community is usually pretty easy, but you want to have their support, and that helps push the initiative forward. Service providers are going to be important to bring in. The public defenders, once they're in, are going to be negotiating and trying to tailor an individual's needs to a service order in the judgment and sentence where the person's ordered to get specific services. It's good to bring in those service providers because if they're going to start getting calls from the public defender, it'd be nice for them to know that ahead of time. Prosecution, the attorneys, it's something that sort of I think a lot of people don't think about it, but often the biggest proponent for a public defense system are the prosecutors. Because if you're in a system and you're a prosecutor and there's no defense attorney on the other side, you're really limited on what you can do and talk to that defendant about. And you have to be really careful. You can't do anything that seems like you're misleading them or anything. And having an attorney on the other side that the prosecutor can talk to without worrying about violating the ethical rules of talking to the unrepresented defendant or saying something that they shouldn't, or having somebody that understands the criminal process so that you can really discuss it, and having somebody who can counsel the client to sort of talk to them about the realities of where they are. Often the prosecution really, really, really wants that public defender there so that they can do the things that the prosecution has been having to do because the person's unrepresented. Often you'll see that with the judges as well. You have defendants coming in, they're not represented. They say they don't know what's going on. They say they don't understand. Having a public defender who can explain things to the client can really help the court. And so judges are often also big proponents. If there's current defense practitioners, if there's people that are taking private cases that in the tribal court as paid criminal defense attorneys, having them involved so that you can kind of see how the court treats the not a public defender, but criminal defense. And then if there's any experts that you can bring from local, state, or tribal organizations, other tribes that have established public defenders, having some advice and people that can help mentor a new public defense agency is also helpful. And there are those organizations out there. There are many tribal, state, national organizations that provide expertise in the area of tribal practice and in public defense generally. And they're often very happy to help and provide some guidance for a new public defender. Here in Washington, for instance, we have the Washington Defender Association, which provides training to the state public defenders. They have often offered defense training and things that they're available. Public defenders can go there to get, tribal public defenders can go there to get services. The big national organization is the NLADA, National Legal Aid and Defender Association. They have a lot of services and trainings available. Often the states will have very strong public defender training programs that often tribal public defenders will be able to tap into and attend. There's nonprofits like mine that provide services to tribal communities and court systems, so you can look for those. Law schools, again, often are, a public, if there's, especially, we've had really good luck with the clinic. Some of our best friends, for instance, were the law school's ethics professors, the public responsibility professors, the ones that taught all of the rules for attorneys and how to practice ethically. They were always available for us to pitch scenarios to them so that they could tell us what we could do and what we couldn't do. So law schools are often happy, professors will be happy to provide that kind of advice. Tribal organizations working with tribal trial and appellate courts, like the National American Indian Court Judges Association, that provides these technical assistance. And then other tribal courts. You can often get mentorship from tribal courts that have an existing public defender, that they'll provide their policies and procedures, their contracts for contracting with public defenders, their rules for who's eligible for getting representation, all of those things most tribes are willing to share with other tribes. The kind of experts you want to draw in, funding, if anybody that's good at writing grants would be great to bring in. If there's somebody that helps the court, for instance, write the CTAS grants from Department of Justice, you can seek funding for public defense, some things through that. It's a little bit limited, but you can get some things through that, as well as if there's other private opportunities. So somebody that can help with the budgeting of getting hard dollars from the tribal budgeting process to get the public defense system up and going. Community engagement, if there's sort of community leaders that are interested in this. Like I said, usually a public defender is popular amongst the community at a tribe. So finding someone who is an advocate for these kind of programs and asking them to help engage the community would be great. Practice standards, looking at these national organizations, because they've done a lot of training on what level of training you need to have to be able to do certain types of cases. Caseload standards, how many cases a public defender should carry. Again, training opportunities. There's a lot of in-state training. There's a lot of national training, and there's a lot of online training that are available for people that if you look for it. Evaluation is helpful because you want to be able to measure and then report how the public defender is doing, how many cases, that kind of thing. Resource development, if there's anybody in the tribe that sort of helps cultivate money and knows how to get funding, look for those. And then office structure. And again, this is probably a mentorship thing where you're looking at other programs just to look how their public defender is structured to see what would work best for your tribe. In doing this, the group should take a look at a lot of existing things. So current criminal and child welfare jurisdiction, you'd need to read the codes to make sure there's nothing in there that would bar you from having a public defender. Occasionally we found things in codes that needed to be changed because of the way codes were written. It almost looked like they didn't allow it for criminal and child welfare. You want to look at your tribal law and your court procedures, because the court is going to have to come up with new procedures to integrate the identification of who's eligible, who wants an attorney, and then how to get that attorney appointed and how to get that attorney at the hearing as early as possible in the criminal case. So those procedures for the court will need to change. I think looking at partnerships, reviewing the partnerships that you may want to make early on. Looking at the sort of national defense practice standards to see how that can be adapted. And then that conflicts issue. What are you going to do to provide representation to people when there's a conflict? So then when you start writing your proposal, all of that's going to inform the proposal that you're going to write. How's the structure of the proposed public defender office? Is it going to be a dedicated agency in the tribe? Are you going to create a new nonprofit? Are you going to contract with an existing nonprofit? Are you going to have individual contracts with individual attorneys? Look at your anticipated caseload. Take a look at how many cases, how many criminal cases are you going to have filed in a year in that court? That'll give you a little bit of an idea of how much attorney time you're going to need to contract or hire. Also, the types of cases, criminal cases tend to be quicker. And so in a year, a public defender that does criminal can take on more individual cases than, say, a public defender who does parent representation and child welfare cases. Those cases go on a long time. And so the caseload is different. So you need to look at it. Think about what cases are you going to provide a public defender and how much of a burden on that is to help you figure out the total number of attorney hours you're going to need. Are you going to require bar membership? Or are you going to allow spokespersons? What kind of training issues? If you're going to, if you're going to create an agency and you're going to hire a young attorney to be the public defender, do you have access to training for them immediately, or anybody that can help them as a mentor? Again, funding needs, going after the funding, putting in place ethical standards. If they're attorneys, they're going to be bound by the Washington, not the Washington, but any of the states' bar associations. They're bound by those, even if they're practicing in tribal court. So the court will automatically get sort of an ethical system for attorneys who are practicing in the tribal court. But if you're going to have spokespersons, those don't apply to spokespersons. And so you want to make sure you don't start having spokespersons taking cases if you don't have a tribal sort of set of rules of ethics that guide them and allow you to discipline them if they act unethically. Then again, evaluation and review, the ability to look at the process and the program to improve it. Then just whatever else you think you need to add in there. The proposal should be presented then to the decision-making body, to the tribal council. You should bring them in from the beginning. Try to get somebody from the council to participate on the planning team, so it's not a surprise to them, because you don't want to come in with a proposal for a public defender completely written and not have talked to them about it. But then when it's ready to go, sort of present it to the tribal council officially. Have the team there be ready to answer questions. Tribal council is probably going to have questions, and to be able to provide additional information. And then it's always good to have community meetings. So to keep the community informed as you're planning, and then sort of when you're in the final stages, be able to present to the community sort of the whole vision for the public defense system. If the public defender office is approved to provide these services, you need to have an agreement. So if you're not going to do it as an in-house agency or a department, then look to have an agreement and a contract with whoever you're going to be using, so that everybody's on the same page of what those expectations are. You need to make sure that it addresses compliance, that make sure that they are agreeing that they're going to keep up on training and any certifications or memberships that they need to have. If they're going to take the contract and your contract expectation is that they're going to be an attorney in good standing, then the contract needs to say that they have to remain an attorney in good standing, that they're not just going to quit paying their bar dues and be dropped as an attorney because they're practicing in the tribal court when you want them to be a licensed attorney. One of the things that's important for you as the tribe to think about is that you can't contract and order them in a contract to release information that's privileged. Attorneys have a privileged relationship with their clients. We're not allowed to give information about them. And so the agreements that you have in a contract can't require us to violate our rules of professional conduct. So you need to be clear about that. And then clearly state when any required reports are being submitted. So you want, if you're setting up with an outside public defender, you want to get information from them so that you can use it for grant writing and other things. How many cases do they take a year? What kind of cases are they being appointed to? So you can keep track of what the public defender is doing, what kind of cases they're handling, and how many total cases are they getting. I forgot to change something in this next slide. So I'm going to be answering the questions. So are there any questions?
Thank you, Ron. We have a couple questions. One was, due to the cost of establishing a public defender, Have you found that there are strong arguments for trying to get people on board as to why that would be valuable to the tribe?
Yeah, I mean, that's the biggest barrier. So you have to have a really strong argument why the tribal council should take money that it could spend other places and do it on the public defender. That's why you really need community buy-in. It's a little easier to justify this than a lot of other things, because if you're at a tribe that's had a tribal court for a while and has been prosecuting people without a public defender, there is absolutely going to be pressure being placed on the tribal council to have a public defender, because people know that if they were in the state, they would get one. And it doesn't seem fair, nor is it fair, to be in a situation to where the tribe is represented by a prosecutor who really understands the criminal process, knows what they're supposed to do, and can kind of, bully the defendant who's unrepresented, who doesn't know anything about the process or the law. That is something that often the community wants. And so that's your biggest sell to the tribal council to use hard dollars, is that it's unfair now. You'll get a lot of political points for doing it, and it is the right thing. And most tribal councils want to do the right thing. And so I think if you justify it and have the court come in and say, it's also really powerful when you've got the prosecutor who can come in and say, look, this really makes my life easier because it's difficult for me to be able to have frank conversations with defendants that I'm prosecuting. A public defender can do that. They can counsel the defendant about why it's a good idea to take a plea offer. It's also good for the system because the public defender can also point out when the police are doing their job wrong. And often tribal council members are, they want their police departments to be doing their job right. And so that's also a good argument to be made. But it's going to boil down to money. Do they have enough money to create some sort of public defense system or not?
Thank you. And last question, after doing all the work to get a public defender established, in your practice and what you've seen, do they generally continue on, or are they successful, or do they fold? What do you see the future of those newly established programs being?
I haven't seen a ton of them fold. I think because tribal councils understand, I think what you see is the public defender doesn't be created in the first place. So that's something that tribal council is very nervous about, is giving a service like this to its members and then having to take it away. And this is a pretty sizable service. So I think they're always going to be nervous about it. There are certainly examples of tribes, for instance, who have gotten, say, the US DOJ TICLA money to create a public defender, and then weren't able or willing to put up the hard dollars to keep it going. There's certainly examples of that. But, really, I don't know. I mean, is it better to have a public defender for 3 years on a grant and then have it disappear? So at least you have 3 years of people being represented, or is it better to not do it at all and try to work on hard dollars so that it's sustainable for a long time? I don't know what the best answer is. But I think most tribes, when they do this, they really want to make sure that they have enough funding that they feel comfortable that they're going to be able to keep doing it going forward and not have it disappear on them.
Well, thank you so much, Ron, for presenting. We really appreciate it.
Pleasure.
If you have any questions about this webinar, please email us at info@NYJA.org with the subject line as the title of the webinar, which is How to Establish a Tribal Public Defender. You can access the rest of the Tribal Legal Advocacy series through our website at NYJA.org and through links shared on our social media on Facebook and Instagram. Again, thank you for joining us, Ron, and thank you all for watching.
Thank you.